Good morning. Welcome to our first live Q&A for 2022. It was an interesting 2021 and 2020 was even more interesting with all the online and the various ways of, providing legal advice and legal service to people, and also the problems people had. It was quite different than problems they had before the COVID-19 pandemic. But nonetheless, it is 2022, a new year, no curfew. People celebrated Christmas, the holidays, New Year's, and now business has to go on as usual. My name is Advocate Muhammad Abduroaf. I'm a family law expert, and I told myself that I should not delay the start of these videos. It's very easy to do that, and people are obviously posing questions and asking questions, and obviously they have problems. There is nothing new under the sun, and that's why we're here today. There are a few ways of interacting with me. You can do so via those links at the bottom. You can register a question. You can make use of Facebook Live. If you're on Facebook Live on the Advocate Muhammad Abduroaf Facebook page, feel free to pose a question immediately, and I will do that. I'm just checking something out. Let's begin. I have three questions, general questions that people generally ask. Those questions were posed, and I have obviously modified it a bit to make more sense. First question. It is nearly the end of the school holidays, and I have been refused to have any contact with my children despite a parenting plan. What can I do? We were never married and I pay maintenance. Okay, so obviously a general question. I do not know whether or not the parenting plan was made in order of court. If it was made in order of court, obviously I would immediately advise you to go to the police station and lay a complaint of non-compliance with a court order, which is obviously a criminal offense. If it was not made in order of court, unfortunately it's just an agreement between the two parents, which with no legal enforcement. Obviously an order of court is much more powerful than a written agreement that was not seen or reviewed by a court of law, by the Office of the Family Advocate, and by other experts. It's just an agreement between the two of you, and it does not necessarily mean the agreement is in a minor child's best interest. For argument's sake, let's say a mother who is very competent of caring for a minor child, she enters into a parenting plan underrepresented, and the other party has a lawyer, and obviously the whole parenting plan is one-sided and in favor of one parent. If those are the facts, clearly no court looked at it, no childcare expert applied their mind to it, and the mother never had any legal representation. Therefore, it would not make sense for us to enforce or go to the court and say, here's an agreement, or to the police station, here's an agreement that was entered into between the two of us, but it was not made in order of court. Please do something about it. Clearly, that would not really be in the minor child's best interest. If it was in the minor child's best interest to have that agreement entered into, obviously the party should have then legalized it, making an order of court. But now there's a dispute in any event, so the matter has to be looked at. So, to the specific questioner, seeing that you have not had any contact, my advice to you is, if there is a court order in place, a parenting plan that was made in order of court, immediately go to the police station. If that doesn't work, go to the court, get an attorney on board. The person is obviously in contempt of court, and enforce your rights. Something needs to be done as soon as possible. You should exercise contact to your minor children. If there is no parenting plan, if the parenting plan was not made in order of court, it's just an agreement entered into between you and the other parent, my advice to you is approach the court immediately to have the parenting plan made in order of court, or for the court to have to enforce your parental rights and responsibilities upon the other parent, or to deal with this matter. What is in the minor children's best interest regarding care and contact going forward? There needs to be a review. There needs to be an investigation as to what is best for the minor children. And if that is done, obviously, when it comes to the next school holidays, there should not be any problems. I do not, I obviously, if someone goes to a doctor and the person is ill, no, the doctor can't say, you should not have done this, you should not have done that. But many of these scenarios regarding care and contact where people are being refused their rights during the holiday period, many of them are avoidable if the parents, they saw the writings on the wall, they saw the problems that might arise. However, they waited till the last moment, especially when it comes to when they wait till December, they wait till Christmas, New Year's. I'm not saying that you do not have any rights, but the world obviously works much slower during those times. People on holidays, courts are not saying closed, but they do not deal with the matters like they should during the middle of the year, for instance. The second question, this is my week of holiday contact with my two daughters. They are telling me they do not want to return, should be to be returned to their mother. They say their mother is too strict and don't let them have fun at home. What advice do you have for me? Okay, the person is asking me for advice. He's not asking me that he wants to have primary care. If that was the case, I would have obviously advised him accordingly. Now, when it comes to minor children, the question is, do we listen to what minor children want? Or do we listen to what the parents want? Or do we consider what the minor children, what the preferences are? Where does the final decision making come from? For argument's sake, let's just say a minor child, she's going to a certain school, doing extremely well at school, being well cared for academically, extramural, sports, scholastic, everything. She does extremely well. But now she said, you know what? I do not want to live with mom anymore. I want to live with dad because dad takes me to McDonald's every day. We have fun, we have enjoyment. There's a swimming pool, my cousins are there, and everything. And then automatically the grades will come down. The child will suffer because whatever the facts are. Should we listen to the child? Does the child have a say where the child wants to go? Of course not. We as adults, we as parents, we need to apply our brains to these type of matters. And no, kids have certain preferences. They want certain things, and they do not think like adults. They do not necessarily know what is best for them. That's where the parents comes in. If they want to drop out of school and mess up their lives, they can do that when they turn 18 years old. Hopefully not, but their rights are obviously parents do not have any rights over their children once the children become adults, turns 18 years old. But before that, you as a parent, you as a guardian, should exercise your parental rights and responsibilities to your minor child. Yes, the law says we have to listen to the minor child. Has to say, of course, if the child is being abused over there, and the child says, no, I hate living here by my mother, but she's abused me, she hits me all the time, she swears at me, there's domestic violence, my stepdad is rude to me, they don't feed me properly. Yes, we have to listen to that. The court can't give a blind ear to that. And say, we don't listen to kids, we only listen to what the parents have to say. And we have to listen to what the child says. But if the father's situation is not so good as well, there's also chaos, domestic violence there as well, then, does automatically mean if one parent's household is not so hunky-dory, automatically the other parent's house, by default, automatically, magically becomes the perfect home. That's not how the world works. All families have their issues, and no one is perfect. What might be good here might be bad there, but they might have good things as well, which is not so well the other side. So my advice to you is first find out why the minor child properly wants to not stay by the mom. Yes, the minor child's mother is strict, but many parents should be strict, because that's probably best for the minor children. Not being strict could mean the child doesn't do their homework, they don't do their schoolwork, they become rude, they become rebellious, and they become dropouts in life. So we have to obviously limit it. You can't be too strict, but some children requires a parent to be that way. I do not know the facts and the circumstance of the specific household. I might look at 1,000 homes and compartmentalize. You know what? You guys are a bit too strict. You guys are not as strict. You guys need to become more strict because the child is using drugs, cocaine, heroin, whatever the case may be. And the reason for that is because in the past you guys were very lenient. You guys allowed the child to go out with a certain group of friends at 16 years old at night partying, and now all of a sudden the child is now 17 years old, a year later, and the child is addicted to drugs. So those parents should have been more stricter. However, another child became psychologically, worn out, depression, etc., because the parents keeps on scolding the child, not allowing the child to socialize, go out, have a bit of fun, and the child became withdrawn, etc. So those parents were but maybe too strict. I do not know. Each case is different, all facts are different, etc. So my advice to you, question number 2 is investigate, find out, are those valid grounds why the minor child wants to stay with you, and can you care for the minor child? Number one, it seems to me the kids are having fun by you. Does your work allow it? Do you have the time to attend to homework, schooling? Should the children become ill, the extramural, traveling, moving them around, and so on? Making sure they sleep on time, making sure they sleep during at the proper bedtime and wake up on time and be ready for school on time and be at school on time. Do you have the capability to do that? Do they deal with their homework? Go around buying material for the assignments and so on. If you have that capacity and you feel that you can, take on the responsibility of the mother because the children do not want to stay with the mother because they are too strict, and you know for a fact 100% the academic results will not decline, great, wonderful, it's something to consider. But first find the root of the problem. You would not want to swap around children because meaning a child living with one parent obviously entail a child changing schools most of the time. If one parent lives in this suburb and there's a school in that suburb, another child lives with another parent. It depends upon the age of the child, where the child is. If the child is maybe in the final year, swapping schools might not be a good idea. It's easy to say I would like to have primary care, but there are consequences involved. You can have primary care, but are you willing to drive every day an hour? So look into those things. I'm trying to be as objective as possible here, on nobody's side, but at the same time there are certain reality things. But if holistically, considering all factors, everything, it will be in the minor child's best interest to live with you, then wonderful, the court would make such an order. So the third and last question, I see there is an online question. I shall deal with that after the third question. I live in Cape Town and the mother of my child lives in Durban with them. I have primary care of them in terms of a High Court order. The mother is now saying she will not return the children to Cape Town. What are my rights? Simple answer. It is a court order. She has a legal obligation to return the minor children to you. In Cape Town, if she does not do that, she is in contempt of court. What we try to keep things civil, go to the police station and advise the police, I have a court order, the children must be returned. The crime is being committed. If they are not willing to assist you, my apologies for that, then unfortunately you have to approach the court urgently and ask the court to authorize a third party, like a social worker within that area, to remove the children and bring them to you. But you have a court order that would assist you correctly. Obviously, we would not want to expose children to those type of circumstances. Maybe have an attorney also send a letter, someone contact her. We aren't going to. You are adults. It's easy to go to lawyers, to the courts, to the police station, but at the end of the day, it's children see conflict, and we want to avoid that. So find out what the problem is. If it means seeing the children for a day less, but it's a conflict being avoided at that specific circumstances, which you can deal with later on, that's where I'm going to. So have the children placed in your care as soon as possible, and deal with the conflict later on might be the best, and to ensure it never happens again. Okay, so I see there's two questions. The first question, let me deal with that quickly. Copy it. Okay, so you must bear with me here. Question 1. Okay, there's the first question. Let's deal with that. Good day. Is there a specific time frame for a report from the family advocate to be finalized? I am scared my ex-husband is delaying the process. So when it comes to the family advocate's reports, the question would basically be posed, how long is it valid? Does it become stale? Yes, certain circumstances can allow a report to become stale if circumstances have changed. If the family advocate dealt with a certain scenario where the children are living in a certain area, in a certain school, and certain dynamics, and all of a sudden the dynamic changes, the school changes, the age of the children changes, etc., and now the reason for the report has become redundant or has changed. Therefore, there might be a need to have an updated report. For argument's sake, if the family advocacy report was focusing solely on whether or not the father should have primary care and what school the minor children should attend to it, and all of a sudden the mother now relocates to a different province, and now the report came out. Automatically, the report doesn't deal with the current circumstances, the current situation. Generally, we have problems regarding how obtaining a report in the first time, in the first instance, because the family advocate sometimes takes very long to do these investigations and provide the reports. But once the report is finalized, that's where I'm going to, that is when um, the delay in finalizing the court matter based upon a report might become an issue. For argument's sake, if the report was finalized in January 2021 and you're only finalizing the matter in January 2022, or a year later, lots of arguments can be brought up because now the children might have changed schools, dynamics have changed, parents got married, remarried, I do not know what the facts are. So therefore, when a report is finalized by the Office of the Family Advocate, you need to try as best as possible to have the case finalized there and then, the next month or two, because you could, have problems later on whereby somebody will argue that the report is stale. So an answer as to 2 months, 3, 4 months, 5 months, that's difficult because each case is different. Obviously, some reports are fine, some reports can hold for a year because the only issue is basically where the child should remain, primary care by the dad or by the mom. But the facts applicable a year ago and the facts applicable now are basically the same. The father still lives a certain distance away from the school, the mother still works at a certain job, the father still does that. The child is basically a grade different, but the facts and the issues applicable are basically the same. Somebody had to apply their mind to what is best for the minor child moving forward. Okay, so that's the second question. The first question on Facebook Live. Thank you very much for that. Question 2, okay. What can I do, or what can you report a maintenance court or the officers who do not act in according to the Maintenance Act? It's been 21 months since the start of the case, 16 months since an order for financial investigation to be done was on my ex-husband was ordered. I'm reading it verbatim. After he pleaded poverty and started to pay only half of maintenance amount during lockdown. All that I have to show to date is to be repeatedly told my file is missing, case postponed, officials incompetent, disrespectful, and willing to help. What I do under these circumstances, or I advise my clients, you need to start complaining. You need to start going up the ladder. Speak to the Department of Justice, the Provincial Department of Justice. Make a noise. If there are incompetent maintenance officers and they're not doing their job, obviously that is not in the minor child's best interest and something which you want to avoid as best as possible. So, obviously you need a court order. I cannot get the order for you if the process isn't finalized. You need to have the matter go before a magistrate. The magistrate needs to make a final order. She will not make the order just because the maintenance officers are delaying matters. That doesn't make sense. There needs to be a proper inquiry to take place. Complain, Provincial Minister of Justice, whoever they are, go to them, speak to them, lay complaints, and hopefully after doing that, some noise will make its way, or complaints will make its way to the maintenance officers, and they will now finalize the matter. Be a spanner in the wheel, be a problem to them. Because it's not that you going to the maintenance court, it's a child going to the maintenance court and you are representing the maintenance court. So make as much noise as possible and that should be able to assist you. Okay, thank you very much for your time. Thank you for the Facebook Live questioners. I appreciate it very much and I'll see you online hopefully by tomorrow again. Have a lovely day.